I'm David Fowler, one of the authors of a brief that was submitted to the United States Supreme Court the other day in the case of Dobbs versus Jackson Women's Health Organization, a case in front of the Supreme Court involving the constitutionality of Mississippi's law that would ban abortions, elective abortions, after 15 weeks. We submitted a brief on behalf of 22 state policy organizations urging the court to reverse Roe versus Wade. But we made an argument that had never before been presented to the U.S. Supreme Court. It was grounded in the Ninth Amendment. Now, why is this important? You've heard of the doctrine of stare decisis, which simply means essentially that a thing decided should remain decided. It's relying on precedent. Well, we've said this before, and we're not going to change our mind. And that's been the bedeviling situation for pro-life people for the last 48 years. How do we get outside of the court's interpretation of the 14th Amendment in Roe versus Wade? Now, a lot of briefs are being filed to argue that, well, some of the premises for Roe versus Wade, that women without access to abortion cannot compete in the marketplace and get their education and all those things. And now, with a more egalitarian society, we don't need to have abortion for women to make progress in their own personal lives and existence. Others have argued, well, you misunderstood the nature of the criminal law about abortion. Others argue that, well, you need to reverse because the standard of fetal viability, can the fetus survive outside the womb, is just not very workable. How do we do that, particularly with science changing so much? So it's just not practical to have courts trying to make a standard that's constantly changing, which the Constitution shouldn't change. Then we have other kinds of arguments that essentially are saying this is bad public policy. It discriminates. It opens the door to eugenics, and so on and so forth. And Roe and Casey, arguably, because all of those other briefs are doing is arguing within the 14th Amendment, would be controlled by Roe and Casey. You're going to have to convince the court that its analysis in the past was wrong because of some flaw in its analysis. But you're still arguing within the concepts that the court has laid down, which gives it the opportunity to say, we've already considered the 14th Amendment. We've told you for 48 years the 14th Amendment allows abortion. Don't come to me with policy arguments or just practical, pragmatic arguments, because the Constitution is not a practical or pragmatic document. It's not a policy document. So you're in some ways playing into their hands. But because the court has never considered what the Ninth Amendment means and what its relationship is to the 14th Amendment, as law professor Adam McLeod said to the Senate Judiciary Committee back in August of 2019, Roe and Casey are not controlling precedent for this argument. They can't be controlling precedent because it's never been argued. Now, some people would say, well, because it's never been argued, how do we know it'll win? The flip side of the question is, well, how do we know it'll lose? What we do know is that in the seminal, perhaps most important case in the history of the United States Supreme Court, Marbury versus Madison in 1803, the Supreme Court said that it had the authority to review legislative enactments to make sure that they were consistent with the Constitution. And so they looked at various provisions to reach the conclusion that, well, of course, our job is to look at the existing law, the Constitution, look at the law that's been passed and make sure that they're harmonious. But they don't make law. They simply issue a judgment deciding what the law is as between two parties with a conflict. But anyway, in the course of doing that and looking at all the provisions of the Constitution to deduce from it that there is this concept of judicial review, the court said it cannot be presumed that any provision in the Constitution is without meaning. And yet, nobody has ever looked at the meaning of the Ninth Amendment, why it was there, and what was the effect of the adoption of the 14th Amendment, if any, on what the Ninth Amendment guarantees to us. So we filed a brief that avoids the issue of stare decisis. And in another video, I'll explain more about the importance of this brief. I hope you'll join me.